And I'll shut that down. Oh, I'll just shut it off.
Welcome to the lecture on prosecutorial decision making. In this lecture we'll look at how we make decisions to prosecute or not to prosecute. Before looking at this lecture, you should have had a look at part 8.10 of the Tasmania Police Manual and also the guidelines, DPP guidelines on
You can start again if you want. Good groove.
Welcome to the lecture on prosecutorial decision making. In this lecture we're going to look at how we make decisions to prosecute or not to prosecute, and we'll consider the procedural aspects of decision making from a practical perspective. Before watching this lecture you should have had a look at the guidelines on... Come on.
You need to shake it off.
Welcome to the lecture on prosecutorial decision making. In this lecture we're going to look at how we make decisions to prosecute or not to prosecute and consider procedural aspects of decision making from a practical perspective. Before watching this lecture you should have had a look at part 8.10 of the Tasmania Police Manual, which is on Milo, and also the DPP guidelines on discontinuing proceedings, which I've also placed on Milo, and I'll refer to both of these documents as we go through today's lecture. In prosecutorial decision making it's well established that it's for the prosecuting authorities and not the courts to decide who's to be prosecuted and for what offences, and that comes from a case called McGaming and the Queen, which is a High Court case. So you can see that it's an important responsibility that we have as prosecutors to decide who's going to be prosecuted and for what offences. The High Court in a case called Lycodopoulos recognised that it's the prosecutor alone who bears responsibility for making prosecution decisions about whether to prosecute, whether the charge involves aggravated elements or just the basic offence, whether to accept a plea of guilty to a lesser offence, and whether to withdraw a charge. It's been noted that courts have the power to prevent abuses of court process, but it should be understood that as prosecutors we have a very important responsibility in making these decisions about charges and the subsequent withdrawal or downgrading of those charges through the court process. I want to make a couple of comments about the decision to charge or the decision not to charge before we go too much further. When we make a decision to charge someone, it involves putting a defendant on trial and putting them to the expense of defending themselves by hiring counsel, not to mention the stress and anxiety of going through the criminal process. So as prosecutors we need to understand that that's often the effect of what we are doing. Deciding to charge people involves the expenditure of public funds, and so we need to be conscious when we're doing that it involves using public resources and public monies. And so in every case where we're deciding to charge someone, before we file a complaint we need to consider if it's appropriate in all the circumstances. Now, as all of you would understand as police officers, often that question's easily answered. The nature of the charge alone justifies the proceedings being commenced. But that's not always the case, and in some cases it's very important that we stop and we consider whether this is an appropriate thing to do in all the circumstances. And as you'll see later in the unit, we also have to deal with the possibility of costs in criminal cases, applications in situations where prosecutions that we've commenced have subsequently either failed or been withdrawn. In relation to decisions not to charge, that's equally important from our point of view, because in circumstances where we make a decision not to charge a person, that potentially leaves the complainant aggrieved by the process. They can ask for the decision to be reviewed, but they cannot compel a different decision by us in relation to that. So the decisions that we make about that can often have those effects for complainants and other people involved. So we need to consider from their point of view whether we're making the right decision in not charging a person. And it's important, of course, that we take the opportunity to consult with investigators and complainants and other witnesses, particularly where the concern or the reason why we're not proceeding is based on an evidentiary issue that might be resolved with proper consultation.
You got an R and an problem. The R before you start talking.
At all stages of proceedings, we need to consider whether we would accept a plea of guilty to a lesser offence, whether we would agree to withdraw a charge or refuse to withdraw a charge. So depending on who's making the request and at what stages of proceedings, it's important that we give proper consideration to those requests before making a decision. I want to emphasise that it's important that we don't do things because it's convenient or it's easy. The process of plea bargaining can lead to inappropriate outcomes, especially if serious charges are downgraded or withdrawn without proper justification. So in all cases where we're making decisions about withdrawing or amending or downgrading charges, we need to go through the process of considering who's making the request and why, and what the basis of it is, and carefully consider our options before making a decision. So I turn now to what the relevant considerations are for commencing proceedings, and I'll start with 8.10 of the Tasmania Police Manual, which is entitled Decisions to Prosecute. And quite simply, Tasmania Police will prosecute offenders where there is a reasonable prospect of conviction. And I want to compare that with the DPP guidelines, which say a prima facie case is a necessary but not sufficient condition for launching a prosecution. Given the existence of a prima facie case, it must be understood that a prosecution should not proceed if there is no reasonable prospect of a conviction being secured before a hypothetical reasonable jury properly instructed, that is, an impartial jury or a magistrate in the case of summary offences. So having satisfied himself or herself that the evidence is sufficient to justify the institution or continuation of a prosecution, the prosecutor must then consider whether, in the light of the provable facts and the whole of the surrounding circumstances, the public interest requires a prosecution to be pursued. So you can see firstly the requirement both on the Tasmania Police Manual and the DPP guidelines for there to be a reasonable prospect of conviction based on the evidence before we choose to proceed. And you can also see in the DPP guidelines the public interest test in relation to commencing proceedings. So in relation to decisions not to prosecute, the Tasmania Police Manual lists a number of criteria. So even though we might have assessed the case as having a reasonable prospect of conviction, the manual contemplates that even though that might be the case, there might be circumstances that justify the prosecution not being proceeded with in any event. And the criteria include technical breaches of the law, trivial contraventions of the law, vexatious, oppressive and malicious prosecutions, prosecutions that would attract ridicule or bring the law into contempt, unreasonable delay in bringing the prosecution, and where the mental condition of the offender suggests treatment rather than prosecution. And as you go through the course, you'll see that there are other court options in relation to treatment, so therapeutic courts for mental health that may be a better option than pursuing prosecution, and any other proper consideration. So even though we might have a case where the evidence suggests a reasonable prospect of conviction, for one of those grounds listed there, it may be that we can decide appropriately that the public interest doesn't require the prosecution to be maintained. And it's useful again to look at the DPP guidelines for discontinuing proceedings, and when you look through them, I won't go through all of them in detail, the DPP guidelines contain a detailed list of circumstances where it may be appropriate in the public interest not to proceed with a prosecution. And so you can look at some of the ones there: the seriousness, or conversely the triviality of the alleged offence, or that's of a technical nature, so that's similar to the one in the police manual; any mitigating or aggravating circumstances; the youth, age, intelligence, physical health, mental health or special infirmity of the alleged offender, a witness or a victim; the availability and efficacy of any alternatives to prosecution. Just looking through some of them here. The attitude of the victim of the alleged offence to a prosecution. This is a really important one. In a lot of our cases, a victim to an offence will, as you'll be aware as police officers, will provide us with a statement and cooperate in the time immediately after the commission of an offence, but subsequently decide they don't want to be involved in proceedings. And so often we will get representations from complainants or victims saying they no longer wish to give evidence or cooperate in proceedings and ask for them to be withdrawn. It's important as prosecutors that we give appropriate weight to that. It's not an irrelevant consideration, and it's contained in the DPP guidelines, but it's important to realise that it's not the only consideration, and it's not the consideration that dictates our decision making. So while we will always consider the wishes of a victim or complainant, that alone is not always sufficient to determine an attitude to discontinuing the prosecution. Another criteria is the likely length and expense of a trial, and this can be particularly important where a case would be difficult and costly to prove, but the nature of the charge and severity of the charge is extremely minor. So we have a situation there where we're going to expend lots of time and public funds to prove a charge which is relatively minor. So in that sense you can see that that becomes a relevant consideration. And also factors such as the likely outcome in the event of a finding of guilt having regard to the sentencing options. So it may be in a case like that, that even if we went to the expense of proving the charge, a court may not even proceed to a substantial sentence. It may be dismissed under the Sentencing Act, so it may be the type of sentence that in all the circumstances the likely outcome means that the cost and time of the proceedings makes it prohibitive. But they're all considerations which will arise in the individual circumstances of an offence. And you can see that there's many factors which may be relevant and appropriate to consider in making a decision to discontinue a prosecution. Importantly, in the DPP guidelines, they include that a decision whether or not to prosecute must clearly not be influenced by the race, religion, sex, national origin or political associations, activities or beliefs of the alleged offender or any other person involved, personal feelings concerning the offender or the victim, possible political advantage or disadvantage to the government or any political group or party, or the possible effect of the decision on the personal or professional circumstances of those responsible for the prosecution decision. So it's clearly contained there that they are not factors which can be relevant to our decision to discontinue prosecutions. So I'll turn now to talk about the actual procedure in relation to decisions to prosecute or not prosecute, and these relate more so to decisions not to prosecute. In practice where we make decisions to prosecute, while it's important to document that, what I'm talking about more so here is where we're making a decision to discontinue or abandon a charge. In 8.10.3 of the TPM, that says that where a police prosecutor receives a representation from any person, including another police officer, requesting that a charge against any defendant be discontinued or adjourned sine die, the police prosecutor shall make a notation on the running sheet of the court file indicating the date, time and name of person making the representation and the nature of the request. They bring that representation to the officer in charge of the prosecution services. And if the representation is considered to be of questionable propriety, the matter shall be brought to the Divisional Inspector. You'll see as you have more contact with the prosecution running sheets that there's space on the sheet for those notations to be made. It may be that you need to make a separate file note, but it's important that at the time a representation's made, that we make an accurate note of the circumstances and that it be referred to usually a sergeant, but the officer in charge is technically the person who needs to have it referred to be considered. In a lot of cases, we get letters from lawyers who are acting for defendants. Now, in that case, it's not necessary for us to make a separate file note or a separate record because that correspondence will automatically be attached to the file. In those circumstances, what is important is that when we provide a response to that solicitor, telling them what we're going to do, that a record of that correspondence to the solicitor is included on the file, so with their correspondence, so we can see when they've requested that we consider our position in relation to a charge or charges, and when we've given our response. In a lot of cases, we might write a letter, but more so these days we tend to send emails. So it's important where we're sending an email that email's printed and forms part of the file, so that if it's being reviewed, somebody who hasn't been involved in the process can have a look at what happened and what decision was made and why. Very quickly in relation to contest mention, most of you will be familiar with the contest mention process, but in that process, often it is necessary for the prosecutor to make a decision about the future of a charge in court, and it won't always be possible to seek advice or conduct other inquiries as would normally be the case out of court. And the manual provides for that, where it says that when it's not possible for the police prosecutor conducting a contest mention court to obtain advanced approval, that prosecutor may tender no evidence in relation to a charge. You won't be doing contest mention courts immediately when you start prosecuting, but eventually if you do start doing them, it's important that you have a good look at your files and you have communication with the solicitors who are acting for the defendants on those files and identify scope for charges to be discontinued. So when you're in court, you have the ability to make those decisions comfortably without necessarily having to go and get some further advice. But in any case where you're in court and a solicitor, whether it's in contest mention or any other court, a solicitor or a defendant approaches you and asks for charges to be dismissed or adjourned sine die, it's important that you go through the proper process and seek advice and consult with the relevant people, particularly where complainants are involved. They are consulted and they are, their wishes and preferences are recorded, and also the investigating police get the opportunity to comment on any decisions that we might make about those charges where possible. Point 6 in 8.10 makes very clear that decisions not to prosecute are to be objectively based upon the whole of the evidence available and in the public interest, and where appropriate and possible, the divisional inspector who authorised the prosecution and the reporting officer and the complainant should be consulted. So that was the point I was making about the importance of those people being included in the decision making. The officer who authorises the tendering of no evidence or who requests the case be adjourned sine die must reduce the request and reasons for the decision to writing, which is to be endorsed and a copy retained on the file. In practice, what will happen is if you're going to seek approval for a matter to be dismissed or adjourned sine die, you'll bring that to a sergeant's attention, so you bring it to me and say, this is what's been requested, we've reviewed it, and we recommend, or I recommend that we agree to it, and you'll provide a written record of what you've done. And so it may be a memo or a short report, it may be depending on the case, it may be a fairly short note based on the matters that you've considered. I'll have a look at it and say, yes, that seems appropriate, and if that's the case, I'll authorise it by signing it, and then that record is attached to the file. And similarly, where you tender no evidence in court, Part 8 of 8.10 says where no evidence is tendered on a prosecution file or a charge is adjourned sine die and is not likely to proceed, the prosecutor who completes the case is required to make a record of instructions on the file and date and sign that entry. So when you're the prosecutor who completes that, you'll naturally write the outcome and indicate that you offered no evidence on a charge or that it was adjourned sine die. And it's a requirement in all prosecution sections that a record of all the charges that we dismiss or adjourn sine die be kept, and that's subject to audit. One point in relation to the Office of the DPP, in any case where we seek advice from the Office of the DPP, we're not to make a decision contrary to that advice without the consent of the Office of the DPP. So in a lot of cases, because of the nature of the case or the circumstances or because it's indictable, we will seek advice from their office, and where that advice has been received, that advice is to be followed unless they consent to something else being done. So it's important that we realise that where we've consulted, that we're then bound by that advice unless they give us permission to do something different. So to finish, we've covered decision making and how we approach decision making. The decisions that we make are often complex and they can be very difficult to make easily. So it's important that you seek advice about what the best decision to make is and what sort of weight to give to the various considerations. Assessing evidence can be a very difficult exercise, so assessing whether a case has a reasonable prospect of conviction or not is something that can take a lot of practice, and you'll get better at with practice and advice. But it's always the first step in us deciding whether we've got a triable case. So before we consider any public interest considerations, the first step is to ask ourselves, well, do we have a reasonable prospect of conviction? And if the answer to that is yes, and there's no other public interest reason why we wouldn't proceed, then normally it's appropriate that a complaint be lodged. We've talked about the relevant considerations for discontinuing proceedings and then the procedure in relation to discontinuing charges. So to finish, I just want to emphasise the importance of accountability, and that as prosecutors, it's critical that the reasons for our decision making are accurately recorded. And so in a circumstance where after the decision's been made and it's been done, we may have discontinued a charge or withdrawn a charge, adjourned sine die charge, if that is being reviewed by someone independently, that without having to speak to us necessarily about it, they can look at the file and see very clearly what the decision was, why it was made, and the reasons behind that, and that it was done for the proper reasons, and that it would withstand scrutiny. So while it's sometimes very appropriate to discontinue charges, it's important that we're able to substantiate the reasons for doing that. Thank you.
Happy?
I'll be happier when you've edited it and